When representing clients in the purchase or sale of unimproved lots, a licensee's duties extend beyond standard disclosure and contractual guidance. They must also ensure that earnest money deposits are handled in full compliance with Arizona law. Earnest money, which represents the buyer's good faith commitment to complete a purchase, carries added complexity when dealing with raw land or unimproved parcels because these transactions often involve delayed development timelines, pending permits, or UN-issued public reports. The proper handling of these funds is governed by ARS, Section 3.2-2151, ARS, Section 3.2-2185.01, and the Commissioner's Rules R 4-2-8-802 and R4-28-1101, all of which outline strict requirements designed to safeguard consumer interests and maintain the integrity of the transaction. Unlike earnest money for resale homes, funds for unimproved lots are typically subject to escrow requirements until specific statutory conditions are met. According to ARS Section 32-2185.01, when a subdivider accepts earnest money or lot reservation deposits before receiving a public report from the Arizona Department of Real Estate, ADRE, those funds must be fully refundable and held in an escrow account with a licensed escrow company attorney or broker. This ensures that buyers' funds are protected in the event the development fails to receive approval or the buyer elects to cancel prior to the issuance of a public report. The law explicitly prohibits the release or use of such funds by the subdivider for construction or development purposes before regulatory approval is obtained. For example, consider a buyer who reserves Lot 12 in a proposed subdivision outside Flagstaff. The developer has not yet completed the road access or secured the public report from ADRA. If the buyer deposits $5,000 as earnest money to reserve the lot, that amount must be placed in an escrow account and remain refundable until the public report is issued and the buyer reconfirms intent to proceed. If the funds are instead used by the developer for grading or infrastructure before those conditions are satisfied, both the developer and any participating licensees risk disciplinary action under ARS, Section 32-2153 and R4-2-8-1101C for improper handling of client funds and failure to act with honesty and fairness. Once a public report has been issued, the handling of earnest money aligns with traditional escrow procedures. Earnest deposits must be delivered to the escrow agent promptly upon acceptance of the purchase contract, as required by R4-28-802A. Promptly is interpreted by ADRA as within 1 business day, unless otherwise agreed upon in writing. Licensees are also required to provide a receipt or evidence of delivery to the designated broker for record keeping. Fulfilling their obligations under ARS Section 322-151.01 to maintain proper trust account documentation and transaction files. One common mistake in unimproved land sales involves premature release of earnest money to the developer. For instance, a licensee representing a developer in Maricopa County might mistakenly authorize escrow to release the earnest funds after contract acceptance, even though site improvements are not complete and the property has not yet met public report requirements. This act violates ARS Section 32-2185.01C and could result in civil penalties, ADRE sanctions, and potential claims against the broker's trust account. Brokers and licensees must ensure that the purchase contract clearly defines conditions for release, including completion milestones, inspection contingencies, and statutory compliance. Another critical consideration is the disclosure of financial interest. When a licensee is representing both the buyer and a developer or has ownership in the unimproved land. Under R4-28-1101J, a licensee must disclose in writing any direct or indirect interests they or their family have in the property or escrowed funds. Failure to disclose such interest may constitute dishonest dealing under ARS Section 32-2153A3. Additionally, in cases where earnest money disputes arise, such as a buyer canceling after a missed deadline or alleging misrepresentation, licensees must defer to escrow instructions and the terms of the contract rather than attempt to arbitrate or direct disbursement personally. Only the escrow company, based on written consent or judicial order, can release the funds. A licensee who attempts to influence disbursement contrary to contract terms could face sanctions for unprofessional conduct under R4-28-1101. Example, scenario. A licensee represents a buyer purchasing a 1-acre parcel in Pinal County for future home construction. The seller is a small developer awaiting ADRU public report approval. The licensee collects a $10,000 earnest deposit from the buyer and places it in the broker's trust account rather than escrow, assuming it will simplify closing. This violates ARS Section 32-218-5.01, as the deposit must remain in a neutral escrow account until the public report is issued. The buyer later cancels, demanding a refund, but the broker cannot release the funds promptly due to procedural errors. The ADRE may fine or suspend the broker for mishandling trust funds and failing to safeguard consumer money. Review summary. Handling earnest money in the sale of unimproved lots requires strict adherence to statutory and administrative requirements designed to protect consumers from premature or unauthorized fund use. Earnest deposits must be placed in escrow, remain refundable until ADRE issues the public report, and be disbursed only in accordance with written contractual conditions. Licensees must act promptly, disclose any personal interest, and maintain accurate records for all funds received. Compliance with ARS Section 3-2-218-5.01, ARS Section 32-2151, and R4-2-8-802 ensures both the protection of clients and the legal integrity of the transaction. Discussion prompts. Why does Arizona require earnest money for unimproved lots to remain refundable before a public report is issued? Answer: to protect buyers from financial loss if the development is not approved or completed, and to ensure compliance with ADRE subdivision regulations. What should a licensee do if a developer requests early release of earnest funds before project approval? Answer: refuse the release and explain that Arizona law requires funds to remain in escrow until the public report is issued, as per ARS Section 32-2185.01. What is the designated broker's duty regarding earnest money records for unimproved land transactions? Answer: to ensure all funds are deposited promptly, receipts are maintained, and records of disbursements comply with statutory trust account regulations. Closing remarks. The handling of earnest money for unimproved lots represents one of the most regulated aspects of real estate practice in Arizona. It reflects the state's commitment to consumer protection and transparency in early-stage developments. A skilled and compliant licensee not only safeguards their client's investment, but also reinforces public confidence in the profession. Remember, the careful management of client funds is not merely a procedural task. It is a fiduciary duty grounded in ethics, law, and trust.